Good morning, viewers. This is YouTube channel Lex Concilium Foundation, and I am Major General Neelendra Kumar on the playlist NCERT. Our guest today is Justice Abhay Oka, a former judge of the Supreme Court of India. He had been Chief Justice of Karnataka and Bombay High Courts after having put in 19 years of service when he joined the higher judiciary. And after the two stints, as I indicated, of Karnataka and Bombay High Court, he came to the Supreme Court in August 2021 and served there till his retirement in May 2025. Justice Abhay Oka has been widely, his role as a judge has been appreciated, respected, and spoken for its judicial insight, for his frank and bold views, and having administering justice in an impartial manner, yet with due sympathy and sensitivity. The matter today that we intend taking up is something that has made headlines in the last week. This related to a textbook for class 8th that was issued by the National Council for Educational Research and Training, NCERT. And the Indian Express was perhaps the first paper to come up on Tuesday with a report that indicated some disturbance or alarm, or at least a notice for a couple of remarks in this book on a chapter that was headed as Role of Judiciary in our society. In particular, it was highlighted that a portion of that chapter for class 8 students of social sciences read people do experience at various levels of the judiciary, and it indicated corruption, and it said that there is a need to take swift and decisive action against instances of corruption wherever they may arise. This report or this chapter of class 8th book, which was as a part of the new education policy introduced by the present government, contained a portion. This is reported, I have read in the papers, I have not seen the actual book because the book has been withdrawn. It quoted the former Chief Justice of India, B.R. Gavai, having said that instances of corruption and misconduct within the judiciary inevitably have a negative impact on public confidence. And Justice Gavai is said to have in this book further said that transparency and accountability are democratic virtues. A couple of minutes more on this report by the Indian Express. Perhaps eyebrows were raised at this report, and very next day, that is on Tuesday, when this report was published, NCERT halted the sale of the book, and they also expressed regret. But then thereafter, on Wednesday, the Supreme Court took suo motu notice. There was a bench headed by the Chief Justice of India, Surya, Kant, and in that bench was Justice Joymalya, Bagchi, and Vipul, Pancholi. And thereafter, you would recall, it's in public domain as the item or this news or the matter has progressed further. Now, I would request with this introduction about the matter that's being discussed, Justice Abhay Oka, as to please indicate how do you look at this matter?
Thank you, General Sir, for raising this issue. It's a very important issue. And I have seen your podcast. I mean, you have been dealing with very important issues concerning judiciary. So I must compliment you for that. See, there are two parts of it. Firstly, I will say what I feel about this particular lesson in the book. And secondly, the response of the judiciary. Actually, there are two parts of the article. One part has gone unnoticed. Firstly, I feel that whether there should be criticism of any institution, constitutional institution in textbook or not, it is an issue to be decided by academicians. I am not an academician. But what I feel is if academicians feel that there should be criticism of judiciary, it should be correct, complete and fair. How it is not correct and complete, I'll deal with later. If academician feels like incorporating criticism of judiciary in a lesson, fairness would have required NCERT to refer the draft lesson or draft article to the Secretary General of Supreme Court so that there can be official response on the criticism, because students cannot be told only one side of it. Now, there are two parts of it. First part is justice delayed is justice denied. There is a caption. Under that caption, the book publishes figures of pendency. 4.70 crores cases in our taluka and district courts, more than 60 lakhs cases in our high courts, and 85,000 cases in Supreme Court broadly. Now, these figures are taken on from public domain. They are on National Judicial Data Grid, no issue about it. And it also says that maybe it will take 50 years to get rid of arrears. Now, here the story is not complete. They must also say why this pendency. One of the foremost reasons is we don't have adequate judge strength. In 2002, Supreme Court passed a reportable order that in India, there should be minimum judge to population ratio of 50, that is 50 judges for 10 lakh population. And Supreme Court order refers to judge to population ratio in many Western countries, which is far above 50. And Supreme Court says it should be done within 5 years. So by 2007, judge to population ratio should have been 50 per million. Other day in Parliament, it was disclosed by the Honorable Minister that today we are struggling at 23. So after 24 years of Supreme Court order, which expected judge to population ratio of 50, today we are struggling at 23. Meanwhile, during last 24 years, population has gone up, nature of litigation and number of litigations have gone up. This is one reason. Second reason is that before the High Court and Supreme Court, government and government entities are the main litigants. They file large number of litigations. And third, of course, you can say that within the limitations on the infrastructure, limitation on number of judges, judiciary is not performing adequately. But first 2 points must be highlighted, because if you are not highlighting those points, then you are not pointing out complete failure of the state governments to appoint adequate number of judges. This is one part. So here the story is incomplete. It is not correct, because if they want students to think about the after effects of huge pendency in judiciary, students must be told the reasons so that there is proper thinking on their part. Then second is, title is corruption in judiciary. I must say here at the outset that no one can say that there is no corruption in judiciary. Judiciary, just like any other institution or our constitution, it cannot be perfect. It is not perfect. Which somebody can, with justification, say that there is corruption in the judiciary, and I don't think anybody should deny it. So let us now have quarrel on that. Now, what is stated below this caption of corruption in judiciary? First is they refer to code of conduct as Bangalore principles. Secondly, they refer to a grievance redress mechanism available, and it is stated that between 2017 to 2021, 1,600 complaints were received. Now, I want to make one thing very clear. Judges perform a peculiar role, and therefore number of complaints filed cannot be the yardstick to decide the extent of corruption in judiciary. I'll make this good. As a judge of the High Court, I used to decide, say, 75 cases per day. So every day, 75 litigants are aggrieved of my orders. I can pass order in favor of only one party. I can't compromise on that. So out of 75 parties, let us assume that 4 to 5 will be cantankerous. They will feel like filing complaints against the judge because they have suffered adverse order. Now, let us see today's scenario. There are 810 or 812 High Court judges. Let us take it that, according to me, everybody decides more than 1,000 cases a year, but let us take it at 500, correct? So yes. 4 lakhs cases are being decided per year by the High Court judges. And if there are, say, 5,000 complaints, most of the complaints are frivolous. So this is not yardstick. Now you are talking about 1,600 and odd complaints between 2017 to 21. Let us assume that judge strength at that time was 700 or 600. Let us take it 600. So there were disposal of 3 lakh cases per judge. Total 600 judges disposal of 3 lakh cases minimum. It should be 6 lakhs also. So what is the significance of this figure of 1,600 complaints? In fact, I can say this. I used to say in lighter vein that if there are no complaints against the judge, that shows that he's not working. He's not delivering the bold judgment. So, short, what I'm saying is only saying that there are number of complaints. That is no indication, no measure, no yardstick of corruption in judiciary. While I say that corruption is there, I can't deny it. As much as people are saying there is a corruption, maybe you can criticize that there is no proper grievance redress mechanism, in the sense that people don't know how the complaints are dealt with. Justified criticism, it could have been answered by judiciary. And the third part of this corruption in judiciary is Justice Gawai's statement. where he candidly says, as Chief Justice, there is a corruption in judiciary and we need to deal with it. Now, the problem is that this is half truth, and you are applying wrong yardstick to decide there is a corruption, and you are not understanding the role of judges. By very nature of role of judges, we are bound to invite complaints. I'm not saying that every complaint is false. There may be complaints which are fully justified.
Yes.
I was part of administration of two high courts. We used to take action against the judges. All complaints were scrutinized of the district and civil judges. So therefore, this is incomplete. This is misleading. Now, tomorrow somebody is to say in the book under a title, Corruption in Politics, and give figures of how many politicians are involved in crimes. If you read the affidavits filed by the candidates in support of their candidature, they disclose number of offences registered against them. So saying that there are against 2000 legislatures, there are complaints filed. Are you going to say that entire all legislators are corrupt? You can't say that. Or you say that corruption in police, there are 500 cases filed against the police officers. That doesn't make entire police machinery corrupt. So therefore, this story is incomplete. It conceals something and it is not fair. This is one part. And I am again saying it is for the academicians to decide whether a criticism of constitutional institutions should be there in the textbook of 8th standard or not. It is for them to decide. I make it very clear. Please do it, but do it in fair, correct, and complete manner. Now I go to the second part. What I personally feel is there are two categories of contempt. One is, I'll give an illustration. Suppose I pass an order as a judge that don't cut trees for any public project unless you plant X number of trees. And without waiting for my permission, either they cut the trees or they don't do compensatory afforestation. It's a very serious case of contempt. Or I pass an order that don't demolish a hutment and it is demolished. Court, as a court, we must take very harsh and strict action against the contempt laws, those who defy the orders, because this is compounding injustice. There is number one. The second category of contempt is where there is attack on the dignity or integrity of the judiciary. And in second category, my personal view, which may again be wrong, is that our response has to be measured. What has been done by the Supreme Court? Let us come to that. Firstly, I must say that it is absolutely correct action on the part of Supreme Court to take suo motu action, because it is not only about the judiciary, it is about the education, because we are going to teach something to 8th standard student, and can we give them incomplete data or incomplete facts? And the other issue will be, of course, wider issue, which is to be answered by academicians, whether such criticism can be there in textbooks. Textbook should ideally contain information. So that's what academicians to decide. So Supreme Court takes cognizance, absolutely correct move. Then Mr. Tushar Mehta, learned Solicitor General, appears. He says that NCERT has tendered apology. We are stopping distribution of these books. We'll rewrite the chapter and we'll correct ourselves. In short, that is the response of Mr. Tushar Mehta. Supreme Court says prima facie this is contempt. And look at the direction issued by the Supreme Court. The first direction is that this book should be taken off from the shelf, either online or offline. This first direction. Second direction is that even the principals of the schools have been directed to seize the books. And third is whether there is a complete ban on books. Now, these are the three directions which are quite debatable. Because even assuming that there is a serious contempt, question is whether Supreme Court can ban a book completely. These three directions, propriety of telling principals, then go and seize books from all the students. So my view is that action for contempt is justified. But I think somewhere Supreme Court will have to draw a line, because government has promised action.
Yes.
And there are further directions, filing affidavit, etc. Now, so firstly, according to me, our reaction should be very measured. And one apprehension which I have, with full justification, Supreme Court had done it, but one apprehension is this should not give opportunity to the government to get rid of very good academicians from NCERT by starting some blame game, because there are good academicians with NCERT and everyone knows what is happening with such institutions. So this cannot be used as a tool to get rid of good people. So these three directions really call for a debate. And I'll end my reaction by saying that, there are two principles. One principle is by a great and eminent jurist, just Lord Denning.
Yes.
Dealing with contempt jurisdiction, I'm not quoting his words, but what he exactly said. I can't quote, but substance of it I'll tell you. What he says is that you cannot use contempt jurisdiction to uphold the dignity of the courts. The dignity of courts must rest on surer foundations. This is what Justice Denning has said. And this is what my response is to latter part of the directions issued by the Supreme Court.
I have a few questions.
Please.
Now, Justice Oak, the talk about the huge pendency is not something new. It's been going on for decades, that the judiciary is inundated with the cases and the cases keep piling up. It is also said that justice should not only be done, it should seem to have been done. And seen to have been done, I am taking a little broader view of that. It is for the judiciary to also take on some part of education to apprise the people at large, since they are the custodians of the constitution, to bring out these difficulties, that these are the problems. Perhaps they bring out, like you have said, that the report, to be fair, they ought to have sent a copy of the text for approval of the Supreme Court at the appropriate level. What is stopping, what is preventing, hindering the judiciary in tackling and combating this pendency? Some sort of action should be taken to apprise a common person, to bring out that, look, in so many cases it is one or the other party who seeks adjournment and thereby the cases are delayed, or whatever are the reasons, so that it brings out. The second is, often it is talked about this judges ratio, judges to public ratio. But it is also believed that the appointment, the recruitment to the judiciary is primarily in the hands of the judiciary. As far as the district level is concerned, the recruitment is done by the state high courts concerned. Now, what is preventing, what is their difficulty? Are there sort of results not being implemented thereafter, appointment letters not being issued by the government? Whether the judiciary has fulfilled its obligations to get the requisite number of judges. What is UPSC is doing insofar as judiciary is concerned, the action to appoint the judges, a major role is there of the high courts concerned also. And insofar as the higher judiciary is concerned, it is said that look, Allahabad, the sanctioned number of posts are so many and only so many judges are actually present. Now, in this also, let Supreme Court come clean and indicate that, look, in all such cases where the date of retirement is known, the first day a person assumes office, takes oath, and there is a system that 6 months in advance or whatever is the period, the intimation is given and the collegium meets and sends the recommendations, and it is thereafter for the union to appoint. So I think there is a time that while the shortage of judges is a major problem, but whether the judiciary is fulfilling its obligation to that, that is one thing I would request you to respond. Now, coming to this report, yes, there is a full chapter, and I sort of plead ignorance. I have not gone through the chapter. The book is not available in any case. It's been all copies. They have said that they have been retrieved and there are no copies on the shelf. That the students of class 8 should not merely be informed, they should also be educated. So, whatever are the problems, difficulties, they should be brought out. That just because the corruption is in other organs of the government, would it be adequate to say that, well, judiciary is no different? So it's like saying, okay, well, everybody is there like this, so we are also part of the same citizens, because the expectations from judiciary as enshrined in the constitution are little more. We have certain expectations, hopes, aspirations in our country, as is written down in that constitution by the framers. And ultimately, the custodians and the last arbitrator is judiciary. तो उनका काम कुछ थोड़ा ज्यादा है, उनसे उम्मीद भी कुछ ज्यादा है. So would you like to comment on
Let's
this?
start with the last thing.
जी.
I talked about complaints by saying that there is a corruption in judiciary, but number of complaints can't be the measure. Number two, you are 100% and more than 100% right when you say that there should not be any corruption in judiciary. And judiciary must set very high standards as compared to executive, IAS or IPS or politician. Absolutely.
Or legislature.
That never has to be there. There is no second opinion about it. Then I'll come to the second question, appointing judges of trial court and district court. Firstly, please remember that we are not financially independent. We cannot create additional posts. The post of civil and district judges and magistrates are created by respective state governments. And High Court has no jurisdiction to say that I will appoint more than what is sanctioned. That is number one. What is happening is it is not only 2002 order. In 2016, bench headed by Justice D.Y. Chandrachud appointed a committee headed by Professor Mohan Gopal, a very renowned academician in the field of law. Then they devised a formula to calculate judges' strength required, and case management committees of all high courts were directed to make calculation and to submit a proposal to the state governments to sanction the posts. I was part of Bombay High Court. I was chairman of the committee. We made a very conservative calculation. Still, additional judge strength required was found to be 8,000. 2016 or 17, we submitted a proposal, and I am told that only 600 posts have been created during last 8 years, though our calculation was 8,000. So what is in the hands of the High Court is to fill up the available strength. Now, there are 2 or 3 processes. First process is to appoint at grassroots level, that is appointment of civil judges come judicial magistrate first class. That recruitment is done by high courts. In some places like Bombay, we take help of the State Public Service Commission to conduct the examination and to hold interviews. In some state, it is done by the high court judges. Second avenue is appointment of direct district judges from the members of the bar. There are rules. The high court conducts written examination and then oral interviews. Thereafter, they are appointed. Third is we granted accelerated promotion to senior civil judges from their post to the district judges, for which competitive examination interviews are there. Then interviews, interviews for regular promotion from civil judges, senior civil judges to district judges. That's all done by the High Court. Now, if you take statistics, you will realize that some of the high courts are supposed to do this process once in a year. For example, I was in Karnataka as a Chief Justice. Appointment of civil judges, we conducted multiple processes in a year, because we do not get adequate number of candidates. And if there is reservation, there is a backlog. So that is the first difficulty. But last 2 years, picture is changing. I think almost all high courts are able to fill in all the posts. But what high court can do is to fill up the sanctioned posts. The state government has to sanction additional posts, and it's not easy. They have to create infrastructure. They have to appoint staff. They have to construct courts, quarters, provide other infrastructure. That is in the hands of the government. Since we are on this topic, we do not have financial autonomy. If Chief Justice wants to purchase a car for the High Court, he has to submit a proposal to the government. Even if we want to purchase computers, we have to submit proposal, government sanctions money. Right. So that independence is not there. Coming to the first part, then I'll deal with the appointment of High Court judges. See, traditionally, we don't respond to criticism. If I was a sitting judge, I would not be talking to you. What are the real difficulties? We are not coming before the public. Now, there also same conventions comes in the way that we don't go before the public and justify our actions or inactions. That is one that is constraint on us. But at the same time, if you read the judgments of the court, for example, there is judgment of the Bombay High Court running in 200 pages that lays down that it is the constitutional duty of the state government to provide infrastructure to judiciary, and what are the aspects of infrastructure and how government is lax. So there are judgments of various courts which incorporate this, that we don't get cooperation of the state government. State government doesn't provide us funds. State government doesn't provide us infrastructure. And talking about Bombay, in fact, there is a writ issued by Bombay High Court that government should grant additional land, a land somewhere else for construction of new complex. Government has not done it on its own. There is a writ of mandamus issue. So we speak in terms of these orders and judgments. But it's a point of debate whether we should be going to public and telling us that, look, why there is pendency of 4 crores 70 lakhs cases, because these are ABC difficulties. Personally, I am a bit conservative about it. Judges should not be doing it, because ultimately it is for others to judge us. And I always believe that when there is criticism of judiciary, we should take it in its own stride. Because, I have said in one of my orders in Bombay High Court that if magnanimity is to be shown, it is to be shown by persons occupying highest judicial office.
Quite right.
Go to public and tell them that these are the difficulties. Yes. But now everything is on public domain. Just strength is on public domain. Pendency is on public domain. Yearly filing is on public domain. So people can draw their own conclusions about High Court judges. Now the difficulty with High Court judges is, the process is that 25% of the posts are filled in from the district judges. So that process continues. There is no difficulty. There is a settled process that their judgments of the judges in zone of consideration are invited. There is scrutiny committee. Scrutiny committee analyzes judgments, and ACR are assessed and ultimately goes before Collegium. And 75% are from the bar. Now the present day difficulty is High Courts recommend the name. High Court Collegium recommends the name. Supreme Court confirms it, or Supreme Court Collegium recommends it. Government takes sometimes 9 months, 10 months, 12 months, 13 months for deciding whether those should be appointed. And half of them are sometimes not appointed. Now the difficulty is when Supreme Court Collegium clears High Court recommendation, it is on public domain, and these are all busy practitioners in the High Court.
Yes.
The moment resolution is published on the website, the workflow stops to the lawyer. And these lawyers are in the age group of 45 to 50. Now, what happens if these people survive without income for 9 months, 10 months, and that also sword of uncertainty hanging on your head, whether government will appoint or government will not appoint. Now, law is very clear. Government has to immediately act upon the recommendation of Supreme Court. If they don't like it, they can refer it for reconsideration. After Supreme Court reconsiders it and says that yes, candidate should be appointed, government has no choice but to sign on a dotted line. That's the judgment of the Constitutional Bench.
Yes.
But that is not happening. So Chief Justices of the High Court find it difficult to persuade young lawyers to accept judgeship because these lawyers are afraid of uncertainty. Not that they are running away from the challenge, but they feel that they will give consent, their name will hang fire for 2 years and their entire life will be affected because of that. I'll give an example. As a Chief Justice, I nominated one of the most brilliant lawyers from Karnataka. His name was approved by Collegium. Government promptly sent it back, reiterated by Collegium, again sent back to the government. Government doesn't follow the mandate of the Constitution Bench. For 1 year, this gentleman waits and he says, I'm sorry, I'm not interested. I withdraw my consent. So for high courts, ideally you are right. 6 months before the vacancy occurs, process has to start. But for that, we need lawyers to come forward and give consent. So this is a very serious issue. There is a lot of uncertainty associated with the process of appointing high court judges.
Yes.
That is proving to be deterrent, and therefore some young lawyers, though they are called by chief justices, young in the sense age group of 45 to 50, they said, sir, no, I don't want to subject myself to this kind of a procedure. Lot of things are required to be corrected at the end of the central government. Though I am saying that there may be cases where delay in sending representations is there. But by and large, chief justices do make effort to persuade the lawyers to accept judgeship. And I personally feel that we should not compromise on quality. When we request some lawyers to accept judgeship, we should not compromise on quality.
Yes, that must not be done.
And someday you must also take notice of the fact of quantum of lawyers' income and salary which high court judges get. But according to me, that is relevant. Personally speaking, I always tell young lawyers that the satisfaction you get as a judge can't be equated in terms of money.
Let's hope that the system or the practice of periodic meeting of the Chief Justices of the High Courts and Supreme Court with the Chief Ministers of the states, such issues would be discussed and some sort of progress would be made to address these problems.
One thing I want to add, I think you had told the truth that common man is ignorant about all these aspects.
Yes, I said that because if there is a museum in the Supreme Court, so in the same way, how is Supreme Court doing? And the matter of redressal of grievances, etc. People should be educated about it. They should be apprised about it.
Absolutely right. Absolutely right.
So that is which perhaps somebody would be listening to your talk and it would ignite some discussion and some progress. Thank you very much, Justice Oka.
Thank you.